Sander versus Westchester Reform Temple. Counsel?
Yes, good afternoon. Bob Herbst for Jesse Sander. May it please the court, we'd like to reserve 3 minutes for rebuttal, if we may.
Yes, absolutely.
Your Honors, we have 4 contentions on this appeal. 1, that blocking outside of work without compensation is a hobby and a recreational activity under Section 201D's broad statutory language.
Does it matter that she was blogging for her organization as opposed to her personal view?
It's not even clear from this record that there was an organization. It was, as I understand it, 2 women blogging under the name Making Mentions, Your Honor.
Right.
So I don't think it would matter at all, because it's not a job-related organization. There's no compensation for it. So I don't think that would matter.
Is both the act and the content of the blogging protected?
Yes, it is, and that's our second contention.
But counsel, before you get there, let's say I'm a baseball fan. That's what I do, my pastime. I have season tickets right behind the visitors' dugout, and I go there and I yell racial slurs at the visiting players. That's how I root for my team, and I'm caught on TV. That covered? I'm being a fan.
If it is a recreational activity, that's a hard case and a much tougher case.
It's the case you're asking us to decide, right? I mean, that's content. I'm a fan. I'm a baseball fan.
Yes, and I would say to Your Honor that content is protected because the broad structure of the statute is to define recreation activities broadly. The legislative history is clear that content should be protected in our view, and they set forth exceptions.
Caught on camera doing that, my employer has no recourse for that.
Well, no. There are, in the subsequent subdivisions of the statute, there are 6 or 7 exceptions.
Which one would apply in my case that I gave you?
Well, one might.
Which one might?
It might be a conflict of interest depending on the employer and what the employer does. After a full record was...
What do you think the employer would have to do to show a material conflict? If the employer showed, for example, that some of its customers were unhappy, not inclined to patronize that business anymore, would that be sufficient?
I think it depends on the facts.
Well, I just gave you some facts as an example. Let's assume that a business is able to show that some public expression of content by an employee means that some of its customers are unhappy and some of them will no longer continue to patronize the business. Is that sufficient to show a conflict in your view?
I think it might, but no such business interest has even been identified in these papers.
Can I ask you also about the legislative history?
Yes.
You know, I went and looked at the origins of this bill, and it seems to me that it started actually as a smokers' rights bill, and then, you know, there was some broad language which was vetoed twice, and then this bill was adopted that was intended, I believe, to be narrower than the initial broader bills. And so that seems to me to be some intention somewhat with your view that this is intended to be a very broad protection.
Well, I think the narrowness came in identifying 4 areas as opposed to a much broader fabric of recreational activity, legal activities.
You agree, don't you, that the initial impetus, and this was true in a number of states, not just New York, was an effort to ensure that employees who were engaged in behavior that employers might find risky, like smoking, could not be fired for that conduct?
Well,
yes?
I'm not clear on whether that was the narrowing. My understanding was...
I mean, that was the initial impetus, though, yes?
I I don't know if that was the initial impetus.
What about the fact that Section 201D2A protects specifically political activities? So if the speech, the content of the speech itself were protected, the legislature surely knows how to do it. So tell me where in the labor law it specifically says content.
Well,
protected.
actually, right there, the part of the legislative history says that an employer should not have the right to forbid a person from engaging in a legal
Legislative
activity.
history, with respect to the statute itself, where specifically does it mention the content of the speech?
Well, the statute doesn't necessarily mention the content of the speech, but
you agree
but
that
it doesn't exclude the
But
speech.
do you agree that the legislature does know how to specifically say so when they want to? They said so with political speech. Why would they not do so for content if that's what they meant?
Well, they did say, I think, with respect to recreational speech, that this bill will ensure that employers do not tell us how to think and play on our own time. Thinking means, if you're going to protect how the employee thinks, you have to extend the protection
But counsel,
to the thinking
Counsel-
that is involved.
getting back to the actual legislation, to the words of the statute, my review of it seems to be that they went out of their way to avoid mentioning expressive activities. Even when they talk about political activities, they talk about running for office or political matters, they talk about joining parties, but they never really, in any of these sections that they protect, seem to refer to expressive conduct. And I walk away from that thinking they actually avoided, they intentionally avoided expressive conduct. Why is that an incorrect reading?
I think it's incorrect because, for example, no employer is going to fire someone for sitting on a sofa and physically engaging in reading. No employer.
Expressive conduct. So we're talking about.
It is expressive.
Reading is expressive conduct?
Reading is expressive. If you're reading Karl Marx or you're reading Karl Rove, the employer can draw inferences as to some of your beliefs.
What about
we do
playing-
that when we select a jury as well, Your Honor.
What about playing in a symphony orchestra? Would that be protected? On your own time? Yeah, but playing.
In a recreational orchestra,
Yeah.
not a professional
No,
one.
no. I mean playing in the local community orchestra. Is that protected?
It might well be.
Well, that would be expressive, I assume, yes?
I think that's a more subtle expressive. But, for example, hang gliding, which was my learned friend emphasized, hang gliding is normally not considered an expressive recreational activity, but it does express
I guess
one's
what-
view of risk, for
Well-
example, and an employer could fire an employee because of how much resources are involved in training that employee, and he doesn't want to take that risk.
Can I divert you for a minute? I'm straight ahead of you. Can I divert you for a minute to the ministerial exception?
Yes, Your Honor.
And to subsection 9 of the statute, which was added subsequently to this litigation. And I guess my question is why there isn't enough in the record here to say that your client fits within the ministerial exception, and shouldn't we take something from the legislature's amendment to add section 9 to the statute to suggest they didn't really mean for this statute to apply in your circumstance?
I don't think that's true, Your Honor, because it is a very limited statute. It actually permits the employer to speak without restriction to employees. It doesn't say anything about the employee's speech. It's a very, very narrow addition, which was not in place, by the way, at the time of this, and it has not been invoked by the other side, I think, for that reason, Your Honor.
And then getting back to the ministerial exception generally on your pleadings?
Yes, the ministerial exception, first of all, as this court decided last year, needs to be decided on a full factual analysis with a full factual record, and we would commend the DeWeese analysis, the Massachusetts Supreme Court's analysis, which I think is the best example we have of a state high court performing the kind of factual analysis that's necessary. They analyzed 10 factors, and if those factors were applied to this case and these pleadings.
What if the job description is clear on its face? May not use the title minister, but the actual description of what the person is going to do fits squarely within the ministerial exception. You still need to do fact-finding?
If it is clear, there are a few cases that on the pleadings invoke the ministerial exception where it was clear that the person was a minister. This is not that case. This is a case in which almost all of the duties were administrative and secular programming, social justice programming, arranging for food after services, a liaison between the
Does
teams.
it matter who you're working for when you're making that definition?
I'm sorry, Your Honor?
When you're saying it's not ministerial, does it matter that the people that she's working, the entity that she's working for, is a religious entity?
Well, it does matter that it's a religious entity because the issue, I don't think, would come up if it were not a religious institution.
So when you're making that definition, doesn't the fact that it is a religious entity impact that determination as to whether or not, although in a different setting, the activities may not be ministerial, but because they are done for a religious entity, that one could consider that they are?
Well, the cases, the ministerial exception cases all arise, as I understand it, in the context of religious institutions and religious schools. But the question is
Well, what about the fact that, you concede this, that is her view, that really the core of her job was teaching and tutoring in Hebrew. What about the link between Hebrew and Judaism, that link, religious link?
Well,
Why doesn't that inform the analysis on its face?
it doesn't form the analysis on its face because this particular teacher was not required to teach classes on religion or religious doctrine or religious curriculum.
I think her offer letter indicated that she was supposed to support certain religious practices and activities like confirmation or religious text study, supporting bat mitzvah education. That's religious.
All we have on that is the unsworn assertions of counsel on the other side. We don't have any evidence yet as to what her real job duties
Well, we
were.
have the offer
Well, we have that letter.
The letter.
We have the letter, but we don't
describes
have any
her-
interpretation of what
the
of
letter
what those
describes-
terms mean.
Her responsibilities if she were to accept the offer.
Yes,
Yes, so
it
why
does,
isn't that
and
sufficient?
they're virtually all secular. They're not.
No, I just pointed out a few things that weren't secular, that were very much religious.
Well, the question, as I understand it, the way these cases are generally decided is the person has to be propagating essentially religious doctrine. They have to be a key employee teaching religious doctrine and so forth.
Do the cases shed any light on an employee who may spend some of their time engaged in religious activity and some engaged in other activity? Is some amount of religious activity enough to invoke the ministerial exception?
It's an overall analysis of the circumstances, but the key question is whether she is someone who is playing a key religious role in the institution. After all, it has a name, ministerial exception,
Where do you
for
get
a
the
reason.
key religious role requirement? What's the law that informs the significance of the religious role?
What's the case, you're saying?
What's the
John?
case, statute, whatever you have?
Well, the Deweese case interpreted the Guadalupe case, the latest Supreme Court case, and it went through all of the deposition testimony that was cited, all of the documents that were explained by
The
witnesses.
Massachusetts case?
The Massachusetts case, Your Honor. And it went through, and it essentially decided that, because in looking at these 10 factors, they were not able to find that she met the ministerial
Let's
exception.
assume for one moment it doesn't satisfy the test, or there's some factual issue around that test. Why isn't the blog, her blog statements, in conflict of the business interest? I mean, it's a Zionist institution, and she understands it as such.
Yes, and she said that she would respect it and not share her contrary views at work, and
But this is about what she actually posted, what she wrote, and those words. Whether or not moving forward her conduct is going to take a different path is another issue. It's about the blog itself.
right, and I think this statute properly interpreted and not narrowly interpreted to exclude conduct says that the expressive views, thinking that are revealed to the employer should not be a
Except
grounds
there's
for
an
firing
exception.
unless...
Yes, except you
Right.
recognize there were exceptions. That was
Correct.
your response to Judge
Correct.
Garcia. I'm asking you about this particular exception.
It's conflict of interest exception. And I would say
Business interest.
that
yeah.
Rabbi Levy, who was the director of the school that hired her, that knew her job duties, he wrote the job description, he read the entire blog post, and he
Well, the fact
explored her
that
views.
one person in the institution would not view it as a conflict
Well, he's the-
resolves the issue?
Well, he's the director of the school, and right now, we don't have any
He's also the
any
one who
evidence
told her
from the
she
other
was
side.
fired.
I'm sorry, Your Honor.
She's also the one who told her she was fired, as I recall.
Yes, that's true. We don't know yet what the circumstances were. We don't know what the emails and communications were that went back and forth. We don't really know what the thinking was
I'm
of the
just saying
people
on
that
its
fired
face,
her.
if she agrees it's a Zionist institution, and that's the institution, right, views itself that way and has that conversation with her, and her statements are anti-Zionist, how is it not a conflict?
Well, it's not a conflict in part because this temple states that it is open to people of all views, and one of the three rabbis professed
Possible
themselves to
that
be...
view is not the one that undermines their existence, right?
If it turns out after a factual, after we get discovery in the case,
Yeah.
that they can prevail on the conflict of interest exception, the case will be lost. That's
What
fine.
would you find in discovery? What would be what the parties are looking for in discovery to either show or show that there's not a conflict of the business interest?
Well, we want to find out. We want to find out what it was that caused Rabbi Levy, after he read the blog post and talked to her for 45 minutes about her views, and said that he agreed with 90% of what she said, and would she reconsider, the anti-Zionist label, and would she read people like Peter Beinart, who calls himself a non-Zionist or a post-Zionist or a cultural Zionist? Why did he write an email, which we haven't seen in 4 years in this case, been hidden by the other side? Why did he write an email fully endorsing her as a good role model for her students and a fine educator? Why did he conclude that there was no conflict of interest? That's what the allegations in this complaint say.
Thank you.
Thank you.
You have your rebuttal.
Good afternoon, Your Honors. Michael Reed, Yankwood LLP, on behalf of the defendants' respondents. The Second Department got it exactly right in this case. The plaintiff failed to state a cause of action because she alleged that she was fired for her viewpoint, not for the act of blogging. The blogging is a complete red herring in this case. The case is identical to the case that Judge Garcia mentioned earlier, perhaps even stronger, where somebody's at a baseball stadium and they're out there making racist remarks. The employer under Section 201D can fire that person.
So
for their
what
viewpoint.
exactly is the line you would have us draw? Is it that all content is unprotected, or that content that is objectionable to some is unprotected?
The line that was drawn by the legislature is that viewpoints are not protected by the statute. Activities
Okay.
are protected.
And so if I, participate in a community theater, for example, it strikes me as a hobby, fair to say?
Yes?
Okay, and the community theater performs a play, and that play may well express a viewpoint. So does that become unprotected because there's a viewpoint? It seems difficult for me to draw those lines.
So, Judge, there might be difficult cases, I understand, where that line drawing
Well, just take that example.
That example I don't think is a difficult one at all.
So
Because
is it protected or unprotected, the community theater?
the act of participating in the community theater is protected as a hobby, but if the termination was because of the viewpoint that the employer thought was being expressed in that theater, then that was not protected by 201.
Gee, it seems like there's a lot of conduct that we might think of as hobbies. What if, to go back to Judge Garcia's hypothetical, what if my point of view is not a racist slur or some view that would be viewed as reprehensible, but that I'm rooting for the Yankees instead of the Mets? That's a point of view, right?
Yes.
And so that would be unprotected, and I could be fired because I'm rooting for the wrong baseball team?
The answer is yes. I mean, that seems very unlikely, but that's what at-will employment is.
So I'm having trouble with your idea that this doesn't concern the content of the expression at all, because if that's right, then I don't understand why you would need the exception for things that are incompatible with the business interest, right? That seems to me to actually invoke content.
So, no, Judge, if we are right on the content part for the recreational activities prong, you can imagine situations where people are engaging in activities that are contrary to what their employers want. You can imagine somebody works for an auto safety group and they're out there not wearing their seatbelt. You can imagine.
But reading necessarily, it seems to me, what books I choose to read reveal my selection of content. And so does that mean that even with reading and watching TV or movies, like hobbies, the employer can say, I think that you're reading the wrong Karl, whether that's Karl Marx or Karl Rove, and so I'm going to terminate you for that?
Yes, the employer can do that because that is a viewpoint and that's not what's protected by the statute.
It seems
Activities
surprising
are
that the legislature would protect reading expressly, but reserve to the employer the right to fire because the employer doesn't like the book that I happen to pick.
Well,
Or put another way, what reading is protected?
the act of reading is protected. Now, you might say that it is unlikely, which I take the import of Your Honor's question, that an employer would fire someone just for the act of reading. But the same thing can be said about the other parts of the statute. No, it's very unlikely an employer will fire you for playing Monopoly, but that's covered. That an employer will fire you for rock collecting or stamp collecting or going jogging. These are all things that are covered. The legislature didn't say writing. They didn't say the creation of content.
But your example seemed to me to suggest that the legislature was trying to protect him something more than the narrow thing that you're saying is protected, right?
I don't think so. The legislature was trying to
Well,
protect.
if people are not likely in the real world to be fired for playing Monopoly, for example, then we can presume, I think, the legislature wasn't trying to protect that because it's not happening.
Judge, I don't think we can because the plain language of the statute and the canons which tell us to
So
read it
your
narrowly.
reading is that the legislature was trying to prevent employers from firing people for things that employers never fire people for.
The reading is that they were trying to fire people for activities, some of which might be very unlikely and some of which might be likelier. They could have protected viewpoint. They made a choice not to do that. And it's improper, I would submit, for us to say just because you would expect perhaps a reading-based termination to have to do with content that we can read out or read a viewpoint into the other parts of the statute, which we can't.
Well, it would mean that an employer can basically circumvent that law easily. Oh, it's not about reading, it's because they read that. It does
Judge,
sound like they read that is exactly what the legislature was concerned about.
Judge, on the facts of this case, it's pretty clear what happened, which was a second
No, I'm just
department.
asking you about that. We're just staying on this particular thread of the argument.
Could you re-ask your question, please?
Well, all I'm saying is it sounds like an employer, under your interpretation, an employer can easily circumvent even the limited protection that you're recognizing.
How so? I don't follow.
Well, it's not about the reading, it's about what they read. Well, then reading is
Well,
never covered, because you can
well-
always say
Well, Judge,
it's about what they read.
I respectfully disagree, because in certain cases, it might be difficult to figure out where to draw that line, and in those cases, you'd have discovery and figure it out. You don't need that here. They alleged that she was fired because of her viewpoint. The blogging is a red herring. There's no allegation that the synagogue was anti-blogging, which it obviously was not.
Well, counsel, what about the ministerial exception? Can we avoid all these thorny issues around which types of conduct are covered and which aren't by just going through the ministerial exception?
The court could. That wasn't passed on below, and we would submit that if that were to be ruled on, the lower courts should rule first. But I'll answer the question put to me, Judge. Yes, you could rule under the ministerial exception. She's clearly a minister under that exception. What we were told by my friend earlier about the exception, in large part, was incorrect. He said that this court decided it needed to be ruled on a full factual record. Not true. The court decided that it was affirmative.
So what is the
defense.
record here that we could rely on?
The record here is the complaint and the
I mean, the substance of it,
offer
not the fact of
Sorry,
it.
sorry. What we have here is a job description that gives her the title of a full-time Jewish educator in the Jewish Learning Lab of a synagogue. Her duties in that role included a parsha of the week, a weekly scripture portion. She was tasked with working on social justice. She was tasked with pre-bar mitzvah studies. All of these things are inherently religious.
And they're all in the letter?
They're all in the offer letter, Judge, yeah. And the idea that one would be a full-time Jewish educator in the Jewish Learning Lab.
So
and
are
have-
you arguing that you don't have to serve in a formal ministerial title
Oh, absolutely.
to do actual ministerial duties?
Yes, Judge, absolutely. So the Supreme Court in the Guadalupe decision said just that. The title is something to be considered, but it's not necessary or sufficient. What matters is whether the person is performing a religious function. And these duties are clearly religious. You can't say that having someone teach children to read scripture is some kind of secular project.
And is there a fraction that becomes de minimis, in your view?
No, I don't think so. And what the Supreme Court told us is that there's no stopwatch test. There's no core duty test. The question is a person performing a religious function? And while, again, there might be difficult line-drawing cases there, the job description here says she's teaching 15 hours a week. And she's also doing social justice work, which in a reform...
Wouldn't it be better to wait and get a factual development of those facts as opposed to relying on the letter? She might not be doing any of those in practice, so why not? Why decide it here at a motion to dismiss and not allow for development of facts?
Yeah, we are asking the court to rule first and foremost on the statutory ground. I think that's our strongest argument, and that's where we'd ask the court to rule. But if the court were to get there, you don't need discovery because the job description tells us what she was supposed to do.
Well, let's say we disagree with you on that. What about the conflict on the business interest? That seems almost more straightforward than the ministerial question.
There's a conflict that is clear on its face. What we learned in the complaint is that the synagogue is a Zionist synagogue. She went and posted a blog post that was about as far to the 180 degrees from that as you could possibly imagine. You couldn't imagine a more material conflict for
What
a
about
synagogue
his
today.
argument that the reality, or at least what she has argued, is that the institution was open to different viewpoints?
Yeah, what's alleged in the complaint is that the institution is open to different viewpoints in its membership. There's no allegation that the institution said we're going to let someone whose views are antithetical to our fundamental principles come teach our kids religion.
To return to Judge Singas's question, it looks to me that Our Lady of Guadalupe was decided on summary judgment, yes? So why shouldn't we allow for the development of a record just like the courts did there?
Because I would ask the court to rule first and foremost on the statutory ground.
I'm saying, I appreciate that, but if we're going to look at the defenses.
If you're going to look at the defenses, you should look at what is in the offer letter. Those are her duties.
Okay, so you're saying that that alone, without any understanding of how that would actually play out, that a record would give us and allow for a ruling on summary judgment?
Yeah. For these duties, I would say yes. It's impossible to be teaching kids
It
scripture.
seems like the cases, there's some line drawing questions about when I am employed as an instructor at a religious institution, and when my obligations really are more those of a minister, in other words, involving the teaching of religious principles or doctrine. How do we know which side it falls on?
I mean, in this case, it's pretty obvious because she's not just teaching at a parochial school, like a K through 12 school, which is where the Supreme Court cases come from. In those schools, you're teaching geography, you're teaching math, you're teaching secular subjects. Here, she's a full-time Jewish educator.
Okay, but she could, I think, maybe you have a different view, but she could be teaching at that institution, and if she's not doing anything that touches on religious principles, it might be difficult to argue she's a minister. So what specifically, in terms of the duties set forth in the offer letter, do you think are plainly about teaching religious principles?
The title, the fact that she's responsible for Shabbat and Havdalah programming, religious ceremonies, that she's doing pre-bar mitzvah tutoring, that she's working on a weekly Torah portion with these kids. Those are the things that I would submit. If I
And
may,
on the weekly Torah portion, is it, why is it clear that what she is doing is something that is in part religious teaching, as opposed to simply helping them master the Hebrew and the Torah portion, in a way that somebody could teach any language without it being imbued with religious doctrine?
she wasn't just teaching language, she was teaching them how to read the Torah, and that's a fundamentally religious activity. You can't just say she's teaching them how to read the words in a secular way. There are choices that one makes when one teaches in translation.
But
And those are
wouldn't that be developed and then presented on summary judgment? I mean, we would have to, I take it, read the offer letter along the lines of what you're laying out for us to reach that conclusion.
Could it, I don't think so, Judge. I think that this is an inherently religious activity, and this is what we have to consider on the motion to dismiss. I'd like to just touch on the issue of this not being a recreational activity. You haven't spoken to that, I believe. So this was pure and simple a protest, even if you could say that the firing was caused by the blogging, which it was not. This still wouldn't satisfy the statute because she wasn't engaging in recreation, she was engaging in a
Well,
protest.
what if she had just posted an article from this organization on her blog and said, I think, and this article was anti-Zionist, and she said, I think this article, I read this, I find this very interesting, I think it made some good points.
So-
Is it recreational then?
In that case, it wouldn't be a protest. She could still be terminated for it because it would be a viewpoint termination. But if you look at what she pled here, the language of this blog calls upon all American Jews to join her in her anti-Zionist journey, to speak out against what she calls genocide, what she calls the American-Israeli military-industrial complex.
So if I'm at dinner, at the dinner table during Thanksgiving, and I'm having a political debate with members of my family and friends, am I recreating?
Are you,
Or am I lodging a protest? Vociferously, by the way.
if you are
Yes.
at Thanksgiving dinner?
Yes.
I mean, I tend to think of a protest as, a public act, which is what this very much was. I view that not as a protest. I mean, if the employer somehow...
So if the blog was limited to the recipients, that would not make it, that would make it recreational?
No, not this blog. There's no way this blog could be recreational because if you look at what she says, she even admits in the blog, before she comes to court and says that this was all about fun and games, she says in the blog, what I'm doing is an exercise in truth, justice, and tikkun olam, which is repairing the world. This blog
And
post
why
was
can't
not
that be recreational? I'm struggling with this idea that something can't be two things at one time. Even if it's an expression of protest, if it's something you're not doing for pay and you're, compelled for other reasons to put it out there, you must be deriving some measure of satisfaction out of doing it, which to me puts it more on the recreational side, even though it might have some elements of protest to it.
It's possible, certainly, that you could be blogging for recreation, but here the whole point was to get her message out and get people to join.
I'm saying you might be protesting for recreation. You might, derive some good feeling out of going out into the world or even writing a blog and, issuing a statement of protest.
Certainly, I would think you could say that about any activity that you could do, and it would, if that were the case, then there'd be no lines to draw at all, because everything would be recreational, and what we know from what we heard earlier from one of your colleagues is that the view was that the statute
Well, not
needed
all
to be
things would
narrow.
be recreational. It would be a little different if you did it at work. If you went in front of your
Yeah.
class and expressed all these anti-Zionist views, that, like I said, now you're paid by your employer and you're doing your employer's business, but this is something she does in the privacy of her own home on her own time.
So I disagree that this was, maybe she typed it in the privacy of her home, but the whole project was to put a protest on the most public medium possible and make it as public as possible so people would join her and affect social change. That's a protest, pure and simple. That's
Judge
even-
Calataro is probably thinking of the fact that I grew up in Berkeley in the 1960s and 70s, and everybody I knew was protesting for fun.
That's exactly what I was wondering.
The thought did not occur to me, Judge, but I'll respond to it. To the extent you do anything, there could be some kind of fun component. But again, that doesn't mean that everything is recreational. The statute started off as a bill to make legal all activities outside of work, which is essentially what I think the hypothetical would become. And the legislature said no.
But maybe
we're not-
recreational just means not for pay.
Recreational doesn't mean just not for pay, Judge, I respectfully say, because then the recreational is surplusage. The statute says that recreational activities that are performed not for pay outside of the employer's premises are protected.
Thank you.
I'd ask this court not to avoid the issue of content. I've been a civil rights lawyer for more than 40 years. When I brought this case in the twilight of my career, I did not think I was defenestrating the protections for recreational activity in this statute. There are two causes, two but-for causes of this termination. One is the blogging, and the other is the message contained in the blogging. They're both but-for causes. We know that if we apply the rule of the Bostock case on determining but-for causation, you change one thing and see what happens. If she weren't engaging in recreational blogging, she would not have been fired. If she had not blogged out this particular blog post, she would not have been fired. They're both but-for causes, and you can have more than one but-for cause. This blogging should be protected. The blog post should be protected.
Well, if she had just, old school, had printed up something and then, nailed it to the trees, that's not blogging, but if it's the same content, they may very well have fired her, right?
Oh, if it doesn't come...
It is about the content.
Yeah, but it also needs to be a recreational activity. It needs to be both. Mm-hmm. So I just wanted to respond to one argument that was made, that there's a difference between the congregants and the leadership, One of these three rabbis...
Wait a minute, let me go back to this thing. It must be both content and the activity. Let's take an example that Judge Halligan gave you before, performing in some kind of musical endeavor, and the employer says, well, I just don't like any music. I don't care what music you were playing. I just don't like anyone playing music. Why?
Well,
that's not about the content of it, right?
I think that would be prohibited also. But that's very unlikely to happen.
Because you said it has to be both. That's why I'm asking about
I mean,
that.
yeah, it has to be a recreational activity.
Will you
and then-
agree if someone just did, if an employer just doesn't like anybody blogging, they don't care if you were blogging about your favorite
I do
turkey
agree.
stuffing.
I
It
do
doesn't
agree.
matter to them.
I
They
do
just
agree.
don't like this idea.
Right.
Right?
Yeah,
If I hired you for that, you would, to the extent that your position is blogging as a recreational activity, you'd say, well, that's covered,
Yes,
right? But your point is also that even if they have no problem with the act, if they wouldn't fire her for the stuffing recipe, but they would fire her for what she actually did post.
yes.
That is also covered.
Yes, and I'm also saying that because really no employer is going to fire someone, because they're sitting
Then why
and
doesn't it
blogging.
say, but then why doesn't it say that you're protected for your speech?
Because I don't think the legislature thought it had to say that in the text,
Well, I've-
because there was no other reason to protect recreational activity the way it is. If you're only going to protect the acts, no one is really going to be fired for the acts. That's the thing. As Judge Halligan, I believe,
Well, it's kind of like
said,
sports. Who's going to fire them for sports? I mean,
Well, I think in terms of hang gliding, for example, I think an employer could fire someone because of the tolerance for risk. The employer doesn't like it. That's prohibited. That
But
should be
didn't Judge
prohibited under
Halligan
the
give the
statute.
example of smoking earlier, and in fact, they added something about smoking marijuana to the statute. Isn't that a pure recreational act?
It would be a recreational act and it would be covered.
Right.
But that
that's
doesn't
one.
exclude.
and it's not even listed. I mean, it's not even listed.
Well, it's separately listed.
Under the
I think
cannabis,
in
right?
the cannabis
Might
portion.
not part of the question we have to sort through here be that when this statute was drafted, I don't think that there were easy mechanisms for an employee to widely disseminate their point of view, right? And now, in the face of social media and the internet, that can fairly readily happen, and so maybe the legislature just didn't contemplate the particular question presented by this set of facts.
Well, I think that is true at the time, but they have amended the statute a number of times. If they were concerned about
it
the
may not have
breadth of
come-
it, they could have narrowed it.
But it may not have come to their attention that it could be applied in this way.
Well, I think it's been clear for actually decades, as long as the internet's been going, that there's a real danger of people being fired for what they post.
Well, if there have been cases
online.
along those lines, I think I missed them, but
Well, I agree this statute has not been used that very much. And part of it, I think, is because of some of the rulings in the lower courts that sort of tended, because of the romantic relationship issues, tended to advocate for a narrow reading. But I think in terms of this, I think this is a really, really important issue, and I hope that your honors will take it up and not avoid it. And I would also ask you to, if your honors are going to reverse, to remand for full discovery, not for a reconsideration of whether on a motion to dismiss the ministerial exception or the conflict of interest exception can be ruled on, because then we might be back up before an appellate court in 2 or 3 years. This case is already 4 years old.
Thank you.
Thank you very much, Your Honor.